Good morning. Good morning. Everyone out there, I hope you had a wonderful weekend. If you're just now joining us, take some time to let us know where you're tuning in from, your city, state, um, and let's see what else can we do. And let us know your favorite summer activity. Hey, good morning, Amari. Coming in from Atlanta. Good to have you with us today. If you're just now joining us, feel free to let us know where you're coming from, your city and state. Would love to know that. And also let us know your favorite summer activity, if you have a favorite summer activity. I know it's a little bit hot this past weekend, so maybe your favorite summer activity could be staying indoors. Hey, good to have you, Nia. Going to concerts, yeah. Feel like there's a lot going on. Hey, we'll get started here just momentarily. Hey, Dean, good morning. Good morning, Tamika. Dean says good friends and adult beverages. It's always nice. Hey, good morning, Erica. Great to have you with us this morning. Yeah, new books are always good, Tamika. If you're just now joining us, good morning. We're so excited to have you here. We have a great session in store for you today. We're going to get started here just momentarily. If you're just now hopping in the session, the prompt for today is share with us your favorite summer activity. All right, well, we are 5 minutes past the 11 o'clock mark. I'm going to go ahead and get started. Again, thank you so much for everyone who's joining us today. Good morning. My name is Jordan McIntosh, and I'm the Community Engagement Coordinator here at Goodwill of North Georgia. And we are super excited to have you here with us today. And I should say, welcome. Welcome, whether you're joining us from home, whether you're joining us from the office, from the gym, welcome to our Career Connector speaker series. If you're unfamiliar with this series, the mission for this is a simple one. It's to help you, whether you are new in your career, or late in career, or looking for employment, to help you upskill, reskill, and give you that edge in your professional journey. So if you're joining us and hopefully that's something you're looking for, then you are in the right place. Before we go ahead and get started, I would like to take a few moments just to talk a little bit about Goodwill's mission. At Goodwill, our mission is a simple one as well. It is to put people to work. And due to your generous donations, as well as your purchases in our DGR and retail stores, we've been able to put over 125,000 individuals to work over the past 5 years. So that's thanks to you, and thank you so much for your support. If you are interested in our programs, we do have a wide variety of programs located at one of our 14 career centers. Some of them include retail, supply chain management, customer service, and then most recently, EVSE, electrical vehicle supply equipment. I will give some more information and drop that in the chat here momentarily, but we would love for you to engage and for our staff give our staff an opportunity to help you in any way we can. So with that, I do want to go ahead, but before I do introduce our speaker, I do have a few housekeeping notes here for today's session. So the first thing is today's session will be recorded. So if you happen to miss part of it, or if you have to leave a little bit earlier, you will get a copy of that for your reference. The second thing is that Q&A function will be on, and our presenter will have some time at the end of the session. Please note, we do ask that we do ask that you do refrain from asking your questions until the end. Actually, better yet, you can ask them now, but they won't be addressed until the end, just so we have an opportunity for our presenter to get through her session. And the last thing I want to note is that the chat function will be on. So if you are finding this enjoyable, please engage. We would love to know that as well. Now, without further ado, I have the privilege of introducing our guests who we're honored to have with us today, Mrs. Bernie Lawrence Watkins. Bernie Lawrence Watkins is a seasoned transactional attorney at the law firm of B. Lawrence Watkins and Associates, PC, concentrating in the areas of music, TV and film, technology, copyright, trademark, and corporate formations. Her clients include Grammy Award-winning music producers, artists, and songwriters whose recordings have sold over 10 million units in sales. Mrs. Lawrence Watkins is known for her sharp negotiating skills and has helped several of her clients earn millions of dollars in revenue. She periodically appears as a guest lecturer and a panelist at colleges, law schools, and conferences nationally and internationally. Bernie Lawrence Watkins currently serves on the board of directors for several nonprofit organizations, including Georgia Music Partners, Girls Make Beats Incorporated, Sickle Cell Disease Association of America, and Choices. Mrs. Lawrence Watkins is also the CAB Entertainment Commission Advisory Board member and adjunct professional at Georgia State University College of Law. Also, Mrs. Lawrence Watkins attributes her success to being able to manage her time between work and family. Bernie Lawrence Watkins is a graduate of Howard University and the University of Baltimore School of Law. And one fun fact is that she was asked to be one of the original members of the iconic hip hop group Salt and Pepper, but that's another story for another time. Bernie, thank you so much again for being here with us. I'm going to turn the floor over to you. Thank you.
Thank you so much, Jordan. It's a pleasure to be here this afternoon. I'm looking forward to this session. This afternoon, we're going to be speaking about the basics of Copyright 101 for entrepreneurs. And I'm going to try my best to do it in 1 hour, which typically takes a full semester to do, because there's a lot involved. Are you all ready for this session? I hope so, because there's a lot of information that I will be giving out. So hopefully you have a pad and pen ready to take notes. We're going to start with the overview. This session will explore the core principles of copyright law. You will be provided with the essential tools to safeguard your creative works of authorship from unauthorized exploitation. Learning the fundamentals of copyright law will help you understand the importance of intellectual property and encourage you to exploit the growth of business through its use. What is copyright? Based on US law, copyright is a form of intellectual property law that grants the author of an original creative work exclusive rights to their work. Copyright is grounded in the US Constitution, which explicitly grants Congress the power to create copyright law under Article 1, Section 8, Clause 8. Congress passed the first copyright law in 1790, which has been updated through Congress passed the first, when Congress passed, the reason why I wanted to talk about the year 1790 is because I want you to understand the history of copyright law and how it is such an important fact of how we conduct business today. Intellectual property is basically how our world functions. There's a lot of money that's being made on intellectual property, and it is really the growth of businesses. The U.S. Copyright Act of 1976 provides the basic framework for copyright law as we know it today. Why does copyright law matter? It drives economic growth and innovation. By giving creators exclusive rights to their work, copyright laws allow them to profit from their investments and recoup their research and development costs. It encourages creators to continue to innovate and create new products and services that benefit society. It helps to ensure that consumers have access to a wide variety of products and services. It prevents other people from exercising the exclusive rights held only by the author of the rights holder for the duration of the copyright. And we'll get into that later during this presentation so you understand that under copyright law, there are exclusive rights that are held only by the copyright holder or the author of the work. To ensure that creativity continues, the federal statute places limitations on the length of copyright protection. In general, the law provides as follows. In the case of one author, it's the life of the author plus 70 years. If multiple authors, it's the life of the last surviving author plus 70 years. Now, how is copyright created? A copyright is defined as an original work of authorship fixed in a tangible medium of expression. So you have to think about it's an original work. So original work means that the work never existed before. And then we look at authorship. The work is created by an author. It's a human, not a machine. So this is the whole argument with AI, because AI is a machine, right? You have to feed that information into a machine, and then there's an output. So the Copyright Act explicitly covers authors, which in turn means a human. So this is important to acknowledge. The other factor that's important is fixed in a tangible medium of expression. That means that the work must be captured either in a writing, a picture, or painting, or recorded in a form of an audio, visual, or computer file. So again, we're talking about the capturing of a work in a fixed, tangible medium. So it has to be tangible. The expression. The detailed elements of the way the work is expressed must have some level of creativity. For example, I'm going to read these two sentences to show you the difference. The boy went to the store. This sentence is too general for copyright protection. There's not any creative elements that are expressed in that sentence. Now listen to the second sentence. The boy with a high top fade, dressed in a red shirt and blue jeans, drove to Whole Foods in a convertible red Mustang. Now this sentence is detailed enough to give more of an expression. So when we talk about expression in a creative sense, it has to be detailed enough so that it can be distinguishable from another person's work. So he has to be again involve a level of creativity that's original. The moment a work is created, ownership of the copyright is granted to the original author. So when I talk about the moment that a creative work is formed, right? It's you have what's called a copyright. A lot of people think that they have to register the work in order for a copyright to exist. That's not how it works. Okay, so the moment the work is created, you have ownership in that copyright. I just wanted to make sure that's clear.
Hey, Bernie.
Registering,
Hey,
yes,
Bernie, this is Jordan. Please excuse me for the interruption. I think our audience is having trouble seeing your slides as they progress.
okay.
Their way. See if
Can
we
you see it?
troubleshoot it. So I believe on this end, we're seeing it on still slide 1. So we need to make sure we can go back and make sure we get coverage of those slides that you have here.
Okay, let me see what's going on here. Let me go by using this one instead. Can you see where we are now?
So I believe I see your mouse. That's perfect. So there's a toggle bar.
So
Yeah,
I'll
I
just
see it moving
go,
now. I see it. Yep,
okay, so I'm in a different document now, so.
that's perfect. Yeah,
Okay.
I think we're seeing it now on our end. If the audience, can you guys? Okay.
Yes.
Okay, great, excellent.
Thank you so much, Bernie.
You're welcome. So registering the creative work with the Copyright Office, which is www.copyright.gov, is not a requirement for ownership in copyright, but can benefit the creator as follows. Registration provides a public record of ownership that the work exists on a certain date. As soon as I see a typo here. Registration affords the author or claimant certain protections under the statute in case of infringement. Another reason why you would register the work is the only way to legally protect the creative work in the case of copyright infringement. So again, a copyright exists the moment that a creative work is placed in a tangible medium of expression. The purpose of registering the work is so that you can be afforded certain protections under the law. There are a lot of people who, in terms of creative works, they will register their work with the Writers Guild of America. That is not an actual copyright. That just serves as a third-party depository for the creative work. Say, for example, if you have a script or a screenplay, you register it with the Writers Guild. A lot of people also talk about mailing a creative work to yourself in a stamped seal envelope for safekeeping. That actually provides no protection under the law. Another name for that is called the poor man's copyright. When it comes to copyright protection, in cases of infringement, in order to file a case in federal court, you have to have registered your copyright with the Library of Congress. That's copyright.gov. If the work is registered prior to the infringement, you can opt to collect attorney's fees and statutory damages between $750 to $30,000 per work based on what's considered fair, and up to $150,000 if the infringement is willful. The petitioner is not required to show actual loss. Again, this is important to note because people wonder, okay, when do I register the copyright? Do I wait until my work is infringed or do I do it before? If you do register it before, you have more protections in a sense where, again, you're able to collect statutory damages and attorney's fees, which is very, very important. And you don't have to show actual loss. Now, if the work is registered after the infringement occurs, the petitioner is subject to actual damages. Registration of copyright relates back to the date of filing. So say, for example, you register the work today, and then a month from now, someone steals your work. Even though you may not receive the registration back until 4 to 6 months from now, it still relates back to the date of filing. Now, registration fees range from between $45 to $50 because there are different forms of registrations. So my recommendation is that you check with the Copyright Office, again, at copyright.gov, to see the different forms that you would have to complete for your copyright. Registration can occur either online via electronic filing through the Electronic Copyright Office. It's known as ECO. You would actually create an account, and if you sit there, read the instructions, it takes approximately, it could take about 30 minutes. I would say give yourself 30 minutes to an hour, but it's definitely something that you can do on your own. Or you can also file via paper filing. And that means mailing the documents to the Copyright Office. That actually takes a lot longer to complete, as well as receive the copyright registration back. There are 3 elements in a copyright notice. You have to use the copyright symbol. So you see the little C with the circle, or you can use the word COPR, which is an abbreviation for copyright, or the word copyright to create a copyright notice. Then you would include the name of the copyright owner, who may not necessarily be the author, and that is in the case of a transfer or assignment or sale of that copyright. And then you would include the year of first publication whenever you're providing the notice. So see, for example, here, you have the C, Bernie Lawrence Watkins, in the year 2008. Or you could do the word copyright, C, Bernie Lawrence Watkins, 2024. So when you create a document, you can actually just put the copyright notice at the bottom of your document or anywhere, somewhere on the document. And this just basically provides to the public who owns or has rights to that document or that file. Matters subject to copyright protection. We have musical compositions, which is songwriting. And the form that you complete for that would be form PA, and PA stands for Performing Arts. Now, when we talk about a musical composition, we're talking about the lyrics, the melody, and the music. This is very important to understand because there are 2 sides in music, and we'll get into that. A musical composition is sometimes called a song. And this is important to understand as well, because when we talk about a recording is different than a song. A song has to deal with the written work, which is called the underlying musical composition. It exists prior to the recording. It's actually the first form that exists in music, regarded as the original and first act of copyright creation. Another form that can be protected is a dramatic work. So when you have, for example, you create a play, or if you write screenplays, or even choreography. So if you create a dance move, that is eligible for copyright protection. And that's Form PA. Again, that's for performing arts. The sound recording is an audio performance. It's an audio file. So we talk about sound recordings, we're looking to the performances that are embodied on that recording. So that's all the sounds that you hear from the vocals, the voices that you hear on that recording. And then also the arrangement of the music producer, and then the music that you hear as well. That is what embodies a sound recording. That is sometimes referred to as a master recording. It's actually the derivative work of a musical composition. Because again, remember I said a musical composition exists first, and then a sound recording is a derivative of that musical composition because it comes after. First there's the composition that's made, and then the recording is made after that. Under the Copyright Act, there are 6 exclusive rights that are provided to the author or the copyright holder. The first right is to reproduce the work. For example, that's copying the work. The second right is the right to create a derivative work of the original work. And that could be translating a book, because you have the book in the original form, and then when you translate it, that's a derivative of the initial book. Transforming a novel or a screenplay into a motion picture. So again, you have a prior work that exists, and then you base that movie off of that previous work. That's considered a derivative work. And then an interpolation of a musical work. So say, for example, you listen to a song, and then there's a certain part of that song that you like, and then you play it over and you record it. That's considered an interpolation. And then you can sample a recording. A sample is when you take an actual piece of that recording. You use that actual recording and you embody it into a new work. So that's considered a derivative work as well. A third form of an exclusive right is rights to distribute the work. So for example, a work is transferred by a sale, lease, rental, or lending. In the terms of music, when you are working with a distributor, for example. So you're giving them rights to distribute the work through a form of a license. Then you have rights to publicly perform the work. When you are at a nightclub, you hear music that's being publicly performed in a club. If you are at a dentist's office and you hear music that's being played in a dental office, that's a public performance. If you hear music on an elevator, that's considered a public performance. In the terms of streaming movies, in sporting events, those are all public performances. Music that's played over the internet, that's a public performance. And it's important to note that a public performance in this sense is related to the musical composition. It does not apply to sound recordings. And we'll talk about that later. The right to publicly display the work is another form of an exclusive right. And the display of a song, lyrics on the internet or via a karaoke machine, for example, that's considered a public display of the work. Or when you display a picture on a signage, that's a public display. or display of visual art in a museum. That's considered a public display. And the sixth right is the right to perform the work publicly by means of a digital transmission. Now, when you are streaming music, that's what this right applies to. And this right applies strictly to sound recordings. Now, how is copyright transferred? Works made for hire doctrine states that if work is created by an employee, authorship and ownership of the work vests in the employer. So say if you are working for the government and they're asking you to create documents, then any documents that you create vest in the ownership of that employer. So any work that you're authorized to create by your employer, if your employer gives you an assignment, then you're actually creating that document for the benefit of your employer. There are two ways that a work made for hire status arises. Works by an employee that creates a work within the scope of their employment will automatically be considered a work made for hire. In the case of creative works, the employer may request the employee to acknowledge work made for hire status in a written agreement. So that's the other way as well. In the form of a written, they may ask you to sign a written document that says that this is a work made for hire. Employee versus the independent contractor test. Now, this is very important because this is a question that arises a lot when there is a person who is employed as an independent contractor, but then they are requested to do things that an employee would do. For example, when you are hiring an independent contractor, if you are telling that independent contractor when to come to work, what time they're supposed to get off, if you are providing that contractor with a computer, if you are giving the contractor their assignments, if they are reporting to work at your location every day, these are all factors that they look to when they are working through the employee versus independent contractor test. They look into the skills required, the source of the tools and instrumentalities used to create the work, the location of the work, the duration of the relationship between the parties, whether the hiring party has the right to assign work, the extent of the hired party's rights to determine when and how long to work, the method of payment. So is there employee taxes that are being removed from the check? The hired party's role in hiring and paying assistance, whether the work is part of the regular business of the hiring party, whether the hiring party is in business, the provisions of employee benefits, and the tax treatment of the hired party. Specially ordered or commissioned work. This is another form of a work made for hire. So where an independent contractor and the commissioning party agree in writing that the work shall be considered a work made for hire, and where the type of work being created fits within the statutory definition of a work made for hire. So there are two types of ownership that arises. The independent contractor will be the initial owner of the work, who then assigns or licenses the rights to the hiring party. So I'll give you an example in music, for example, when you have a music producer who creates the master recording, and then the record label wants to purchase that track from the music producer. So the producer is not an actual employee of the record label. They're independent contract that was hired to create the track. And then they present a producer agreement. The producer agreement stipulates that there's a grant of right clause that says that the producer agrees that that their services are work for hire, and that they agree to sign all the rights and interests of that master that they created over to the record label or to the artist. So that's a prime example. The work will come within the statutory definition of a work made for hire, where the parties may both sign an agreement that must comply with the statutory requirements that the specially ordered or commissioned work can be executed prior to the creative work, including that the agreement states that is a work made for hire and that the agreement be signed by both parties. So the key element here is when the execution of that work, when did the execution of that work take place? Was it done prior to the work in determining a specialty ordered or commissioned work? Now, Congress identified 9 types of creations under the statutory definition of a work made for hire. It's a contribution to a collective work, a motion picture or other audiovisual. There's a translation involved, a supplementary work, which is a work prepared for publication as a secondary adjunct to work by another author for the purpose of introducing, concluding, illustrating, explaining, revising, commenting upon, or assisting in the use of other work, such as forewords, afterwards, pictorial, illustrations, maps, charts, tables, editorial notes, musical arrangements, answer material for tests, bibliographies, appendices, and indexes. So when we look at this, these types of works here are works that you need a collective body. This is not work that can be done by individuals. It usually involves a collective body of people that are involved. A compilation, an instructional text, which is like a literary, pictorial, or graphic work prepared for publication, and the purpose of use in systematic instructional activities, a test, answer material for tests, and an atlas. So these are specific works that, again, the Copyright Act references when we talk about what's considered a commissioned work. Another way that we can talk about the transfer of, the transfer of a copyright is in the form of a co-ownership. Now, co-ownership arises in the form of a joint work. So that's when 2 parties come together and they agree that they're going to work on a matter together. Now, a work prepared by 2 or more authors with the intention that their contributions be merged into an inseparable or interdependent parts of a unilateral whole. That's how the definition is of a joint work is defined. So generally, the joint owners will enter into an agreement that defines their respective duties and rights. But that doesn't always happen. A lot of times you have two or more people that come together and they work on a matter and there's no actual agreement. When an issue arises, the law says the parties, they equally own that work. So it's not a matter of how much a person actually contributed to the work, but more so because that person is considered an original author of the work, then they jointly own the work in equal parts. So that's why it's important to make sure that you have an agreement if you're working in partnership with someone on a joint matter. And if you have a person who is contributing less than you want to make sure it's identified what the split interest is going to be. Otherwise, if that doesn't happen, again, there are going to be issues surrounding what percentages are owned and then the fairness of those percentages. Now we come to the fair use doctrine. In copyright, again, we talked about the exclusive rights to a copyright holder or author of the work, but there are times where fair use allows for a person to use a copyrighted work without seeking permission. And the purpose of this has to relate to the First Amendment. The First Amendment concerns that surround the use of copyrighted work without authorization in connection with criticism, comment, news reporting, teaching, scholarship, and research. And this is very important to understand as well. For example, there are songs that are made with some form of parody, or there may be comedy that involves some form of political satire. They may use a creative work but they create something their own form, but it's in a form of a parody, or it's in a form of, like I said, a political satire, or you may see the news reporting on an occurrence that happened, and they're using a person's copyrighted work. And that all has to do with the fair use doctrine. If they use the picture, for example, that they took that was available on the internet, and they use it to identify a person or to cover a news reporting issue. Those are the fair use comes into play in that aspect. The fair use is considered a defense to copyright infringement. Now, there are 4 factors the courts use to determine fair use. The first is the purpose and character of the use, including whether the use is of a commercial nature or is for nonprofit educational purposes. The second factor is the nature of the copyrighted work. The third is the amounts and the substantiability of the portion used in relation to the copyrighted work as a whole, and the effect of the use upon the potential market for or value of the copyrighted work. There are times where, even though fair use applies, you would find that people will still seek permission, especially when it comes to music, because they just want to make sure that they're maintaining a good relationship with other artists, and that they, even though they don't necessarily have to go through the channels of getting permission, they just do it. Again, just to make sure that there are no issues moving forward with the relationship. Because in the entertainment industry, everything is based on relationships. Well, we have come to the end of the presentation. I thank everyone for attending, and I'd like to open up the floor for questions.
Awesome. Bernie, thank you so much just for giving that insight and just allowing us to get a full scale on what copyright is and how some of the consequences are, right, for breaking copyright and really the methodology and process. You all, as Bernie said, we would love to open the floor just for questions now at the moment. Bernie, while the audience drops their question, I'm going to actually tee one up for us. In the meantime. So thank you for explaining about just the fair use. I definitely did not know a lot about that. I'm sure you've seen it. Can you give an example of, how fair use works, like that you've seen in your work, and just maybe provide a little bit more of that insight for our audience?
Sure. For example, there was a gentleman by the name of Weird Al Yankovic. He was a gentleman that would create all of these parodies of Michael Jackson and actually a lot of famous artists. So that's a prime example. He didn't have to seek permission, but he actually did. So he would create a whole skit based on a song that was created by these artists, but his skit would be humorous. And he had every right to do that because it was allowable under the fair use doctrine. That's a prime example there.
Yeah, and for those who don't know, that is a great example. I remember Weird Al Yankovic, that's way back. But he had many different parodies, and I'm sure that, a lot of people may have thought that, maybe that's breaking the rules, but to your point, fair use allows that. So we have a
Exactly.
question here from Brianna. She asked, we have a couple questions, excuse me. Can you explain under copyright law whether a work made for hire can revert back to the original owner under Section 203?
That's a valid question. So the interesting part about the reversion of rights or termination of rights, under copyright law, perpetuity is 35 years. And in order for rights to revert back, the rights have to be in the author's individual name. If the work is in a company's name, then there's no reversion or termination of rights when it comes to the company that assigned the rights. So I tell clients to make sure that we're dealing with the individual capacity, because the law is very clear on that when we talk about termination of rights.
Awesome, thank you. So we have another question from Erica, and this actually leads into one of the questions concerning about how digital assets and digital content creation has kind of evolved over the years. So Erica says, I'm a retired nail technician, and it was a lady named Robin Mead that was copying for her nail art. She says she posts things on Facebook, IG, and she always uses a disclaimer, use at your own discretion on most of my posts, or use no copyrights intended on song that is the background. She's asking, is this correct? I guess, is this the right methodology for her to use in order to be sure that her digital photos are copyrighted? Essentially, I believe what she's asking is, how can she copyright her photos when she posts?
Well, again, you can put that, again, your copyright exists the moment that a creative work is placed in a tangible form. So you have a copyright when the work is created. In terms of protecting your work from infringement, you can put a copyright notice on your work where you indicate, you put that C on there, or you put copyright on there, and you put your name on there. Like if you see images like Getty Images or of these other companies, they have their names plastered across their work, letting people know who owns that work. So that's how you can do that, how you can protect yourself in the event that someone uses your work. You could easily identify it because your copyright is on that work.
That's
Your
great.
copyright notice is on that work.
That's great. Nia asked, when it comes, so this is another artist, I believe, maybe. So when it comes to freestyles used on social media, since sounds can be monetized, would freestyles used in a reel or video, perhaps like on TikTok, fall within that fair use? Or Nia asked, because it is in the music space, do you have to find the artist to seek permission? I guess going along the lines of maintaining those relationships, and it depends on, I guess, that artist's discretion.
Correct, exactly. Because when it comes to, see, the thing is, especially when it comes to up and coming artists, they are fine with the exploitation of their work to a certain degree because it gives them exposure. So anything that's going to increase their publicity or make that song known, it's fine with them. And so you have to use those snippets with caution. If you, for example, took that snippet and you're now selling it, now we have an issue because now you are profiting off of it.
Thank you. Nia, hopefully that was helpful. Yvonne, so Yvonne asked, so this goes along the line of derivatives. And I know earlier in your presentation, you talked about, translations and, making sure that you understand what is considered copyright or not. So Yvonne asked, she wants to understand if a book and audio or if an ebook is considered a derivative. I think I know the answer, but I'll let you.
Yes, it is. That's
Yep.
a derivative work. That's a prime example of a derivative work. Yes.
Yeah.
Because it originated in original form, which is a written work, and then it's converted now to an audio.
Exactly. There you go, Yvonne. So Jessica asked, or she actually asked a statement. She says she paid and submitted a registration for a copyright to cover a song her kids had written before making their YouTube channel public. Is there anything else that you can think of that she should do to protect that song before making that channel public?
Well, the only way that you can protect yourself from copyright infringement is through the use of registering with the copyright.gov, you registering with the Library of Congress. So now if someone steals your work, you now have prima facie evidence that this registration existed on a particular date with all the details referencing when the song was created and who the authors of that work are. So that is really all you need to move forward with filing a lawsuit in federal court.
Awesome, thank you. And Jessica also says thank you for answering that question. So yeah, absolutely. So another question we got in was on the concept of sharing your work. So when it comes to, well, let me back up. How does international copyright laws differ for those content creators who may be sharing their work, overseas?
Sure. So in the beginning, you saw that I specifically denoted US law. When it comes to international copyright laws, you have to look to that jurisdiction because the laws are going to be different in Germany, in the UK, in Asia. So you really have to know or be familiar with the laws in those various jurisdictions if you have work or any of your creative work in those countries, because it's going to vary.
Thank you. Yeah, it's not a one size fit all for at all.
Yeah.
You have to understand the rules and the regulations there in that specific territory, as Bernie said.
Correct.
Right? That's awesome. So another question that we had is surrounding the lines of Creative Commons licenses. Can you explain the difference between, a copyright versus a Creative Commons license, and then particularly like how does that work?
So when we talk about a copyright, again, a copyright is just a creative work of authorship that is now tangible. Or, for example, I can talk about an idea that I have and something that, or say, for example, there's a song that I think of and I sing it out loud, right? I sing a whole song that comes to mind, but I never captured that song in audio. I didn't record it. I didn't write down the lyrics. I don't have anything that captures that song. That's not a copyright. Now, if I recorded it, that is a different story. Now I have an actual copyright. Okay, because it's in a tangible form. So when we talk about common licenses in the form of when you're licensing work, you're licensing the existence of a work, something that's is in present form. And a copyright holder has exclusive rights to distribute, to reproduce, to create derivative works, to public display of work, to public perform a work, and to actually publicly perform a digital transmission of a work through the form of a sound recording. Those are 6 rights. So you have to, so with those six rights, they can license those works to other people. It can, and a license can be in the form of an exclusive license, or it can be non-exclusive, where they can dictate how many people that they want to give rights to use that same work, because it's non-exclusive.
Excellent. Thank you so much. So we're coming up here on the 12 o'clock mark, so I think this may be a good one just to end it off on. You touched upon this as well early in your presentation. It's about the concept of AI. What role does artificial intelligence and machine learning play when it comes to copyright law? And particularly as it relates to generated content, because I know you being in the music world, it's not just, web images, it's not just photos, now it's going to people's voices at this point. What can you say about that? And how do you think it will affect, or if all, affect the copyright laws in the future?
That's a valid question. In the beginning, I talked about an authorship. We talk about authors. Authors are humans. It's not machines. So in terms of AI, an AI is machine generated. So what's going to have to happen is there's going to have to be some form of medium that comes together to determine when you're using an author's work that's being inputted into these machines, that these original authors are being compensated. Now, when you take work that's in the public domain, so that's public domain works, which is something we didn't talk about. Public domain works means that it's free form. Anybody has a right to use that work. So if you're using public domain work, it's free game. You don't have to clear the rights. But if you're using the rights of a work that's owned by an author, remember, it's the life of the author plus 70 years. So as long as that author has rights to that work, you have to seek clearance from that original author of that work.
That's great. Thank you. And thank you so much just for delineating that. I'm understanding that the rules still apply. It doesn't matter if it's, you still have to have that clearance. And I think that's very insightful just for our audience today. So we've reached our 12:02 mark. We're going to keep it here at that. But we want to thank you, Bernie, just for your time and just for your expertise and just for all the insight and wisdom that you provided here on the session this morning. We are super, super excited just to have learned all of this. Yep, so a lot of the audience was wondering about your contact information. So everyone, that's her contact information there.
There's my contact if you want to reach me.
Yes, so again, we appreciate you. For those who are interested in future sessions like this, please, please, please be on the lookout. Again, you will have a copy of this recording. And for those who are interested in visiting one of our career centers, please visit the link there in the chat. Like I said, our staff would love to greet you, accommodate you, and welcome you no matter where you are in your career journey. So I hope you've learned a lot. I know I certainly did. And we hope that you have a restful rest of your day and you enjoy the rest of your week. Thank you all so much. Bernie, thank you again. You all enjoy the rest of your week.
Thank you for having me. It's been a pleasure. I really enjoyed myself this afternoon.
It has been a pleasure. Thank you.
Goodbye.
Take care, everyone.